Is it a universally millennial experience, learning to set boundaries? It's not a phrase that I remember hearing about until I was into my adulthood. We probably could have used that lesson in high school in that weird period of time after AP exams, but before the end of the school year. I still have a lot to learn about the details of boundary setting and modification, but I think people exposed to the law might have a bit of a leg up. We've seen the power of a clear, bright-line rule, such as people born in the United States are citizen by right of their birth. We have also seen the dangers of an unclear rule, like jurisdiction over a business is anywhere where they might be considered at home. Because that kind of rule sparks a lot of follow-up questions. What does it mean to be at home? Is that where corporations leave their slippers? Where do their dogs live? A former boss once told me that home is where your mom is, while my mother was stationed in a war zone. Is a corporation's home where their mom is? This episode dives into the kind of clarification that controlling precedent necessitated, and I'm going to leave you to decide whether you think the rule is good, bad, or simply unclear. This is Conduct Unbecoming. I'm Erin, and I'm your host. A heads up that all 3 cases discussed in this episode involve sexual misconduct. I'll leave it to you to decide whether this is an episode for you to listen to. And yes, you heard that right, 3 cases. The number of cases kind of necessitates a different format for this episode. The Court of Appeal for the Armed Forces is pretty deliberative, so when I checked their Opinions Digest recently and saw 3 cases published on the same day, my little antenna went up. Then I discovered that all 3 originated with the Air Force Court of Criminal Appeals, which confirmed my suspicion that we had a bit of a theme going. That theme turned out to be reversing the AFCCA's decisions, which had themselves set aside sexual assault guilty findings for legal and factual insufficiency. In each case, the AFCCA determined that the government failed to meet its burden of proving the victim was capable of consenting at the time of the sexual assault and did not, in fact, consent. And, in each case, the AFCCA relied on CAF's decision in the United States versus Mendoza. Let's deal with Airman Nicholas Moore first. While stationed at Hill Air Force Base in Utah in February 2022, Moore was solidly friend-zoned by someone we'll call Airman Abby. Although Abby described Moore as a friend, she also said they didn't really spend any time together or otherwise go out. Which I think it means it's probably more accurate to describe Moore as solidly in acquaintance alley instead of the friend zone, and I think there's probably value in creating more stratification for women looking to describe the men in their orbit. Abby said that the two didn't flirt and that nothing romantic had ever happened between them. She said Moore didn't make those kinds of advances towards her, and that everything had been strictly platonic. In early February 2022, Abby invited Moore and 2 other male airmen over to her barracks room to eat dinner and watch TV. CAF didn't mention the gender breakdown of the group, but AFCCA was sure to highlight it. The group had gathered to watch The Mandalorian, and the 2 other airmen departed at around 10 p.m., leaving Abby and Moore alone in her barracks room, both of them seated on the couch. Abby's feet had been near Moore, who moved them so she could stretch her legs out across his lap. She said she didn't see that as flirtatious. She didn't see stretching her legs out as any kind of sexual advance. Instead, she said that it was something her brothers had done for her when she lived at home. Abby was comfortable and fell asleep. She wasn't pressed against Moore, she wasn't cuddling him, she wasn't spooning him. Notably, she was also fully clothed. When she awoke later, she felt Moore biting or kissing her left ear and digitally penetrating her while lying behind her. Abby said she never consented to that and didn't consent to Moore removing her bra and top or pulling her sweatpants down to her thighs. Abby shoved Moore off of her, asking what the F he was doing. Moore said she was right. He asked if they could discuss what happened in the morning, then he pulled his own pants back on and left. Abby's roommate testified to waking up and hearing Abby crying, then leaving into the hall. Abby ran barefoot to a friend's barracks room, one of the men who'd had dinner with them earlier in the night, and reported what happened. That friend called the Sexual Assault Prevention Response Office to make a report. He took her back to her room to retrieve extra clothes and accompanied her to a medical clinic for a sexual assault examination. The following morning, Abby reported the assault to her master sergeant and first sergeant, and reported to the Air Force Office of Special Investigations to be interviewed about her assault. While she was there, Abby sent a text to Moore that read, "I don't understand how you could do that. I fell asleep on the couch. I thought I could trust you. WTF, I shouldn't have to worry about you taking my shirt off and putting your hands down my pants. I don't understand what you were thinking. I really thought I could trust you." He responded that he knew an apology wouldn't be enough. Abby never spoke with Moore again. She later accepted a transfer to a duty station closer to her boyfriend and further from her assailant. By the time of Moore's court-martial, Abby and her boyfriend had broken up, but they'd been stable at the time of the assault. Abby endured testifying at the general court-martial, and I say endured because a robust defense would seek to discredit her, to undermine her version of events, to paint her as a liar, either as someone who made everything up or someone that led Moore on, tempted him, wanted him to do what he did. Here, the defense focused on Abby's self-described heavy sleeping patterns. They drilled down on the times when she talked while half asleep, the mumbles she made as she fell into her regular sleep, then inquired if perhaps it was possible that on the night in question, Moore asked for and obtained her permission, and she just didn't remember it. Abby responded with the obvious. She was sleeping. Her ex-boyfriend also testified to Abby being a sound sleeper, explaining that he could listen to music at full volume and she wouldn't stir, but that usually movement woke her up. The jostle of a shoulder or bump of an elbow at a movie theater. With him, with someone she was safe with, she'd wake up groggily and return to her slumber. He said that he never had a substantive conversation with Abby as she fell asleep. The panel seems to have preferred Abby's version of events, finding Moore guilty of sexual assault without consent. He was sentenced to confinement for 18 months, reduction to E1, and a dishonorable discharge. He raised 7 issues on appeal, 6 of which were sidestepped by the AFCCA. Putting a pin in Moore, I'm going to turn us to Airman First Class William Hennessy. While serving in Germany in 2018, Hennessy met another airman in the dorm who we'll call Kelly. While they were becoming friends, Kelly invited Hennessy over to, quote, watch videos and funny internet pictures. Reading that summary made me acutely aware of just how old I probably sound to today's youth. While in Kelly's room, Hennessy made himself comfortable, lying down on her bed. Kelly sat next to him and put on their entertainment, and Hennessy crept closer. Kelly leaned away. Hennessy touched her butt before putting his hand on her thigh. Kelly turned the entertainment off, saying their solo time in her room was done, and kicked him out. A year later, someone we'll call Katie arrived on station, and in the months that followed her arrival, Katie and Hennessy matched on some dating website. The two began exchanging messages. About a week after matching, the two met up. Hennessy invited Katie to his room, and she agreed to be there. In the afternoon of June 8th, 2019, Katie visited Hennessy's barracks room, sitting on his couch and watching a show with him. Like with Kelly, Hennessy crept closer to Katie, then reached out to grab her hand. Katie felt weird about things, believing Hennessy was moving too fast because this was literally their first time spending time together. When Hennessy leaned in to try and kiss her, Katie pulled away. He tried again, this time using one hand to grab and hold her face in place for his kiss. Katie again pulled away, and Hennessy apologized, saying he was sorry, that he was super affectionate. Affection requires receptiveness, otherwise it's just sexual aggression. A little under 30 minutes after the forced kiss, Katie slipped away and back to her own room. Hennessy must have finally realized the vibes were bad and messaged her an apology if he was moving too fast. He said he wanted to start again and asked if they could meet for a concert at the Enlisted Club on base that night. Katie agreed, thinking Hennessy's apology was genuine. Toward the end of the concert, Hennessy inquired if they would be returning to his room or hers. Katie replied that she'd go to her room and he would go to his. Then Katie's brother called and she stepped out to answer it. If you get a chance to talk to your family in real time while you're overseas, you take it. While she was on the phone, Hennessy walked up behind her and began rubbing her back. She shrugged off the contact and returned to her call. By the end of the night, Katie, who'd had a few drinks, felt pretty drunk. Hennessy offered her a piggyback ride back to her dorm, which Katie accepted. That was one of her last memories from outside. She came to in Hennessy's barracks room while he was having sex with her. She froze, deciding to pretend she was asleep or that she'd passed out. She closed her eyes and turned her head towards the wall, prompting Hennessy to call her name, shaking her shoulder and trying to get her to open her eyes. But her freeze worked, and Hennessy withdrew and stepped away. Katie stood and gathered her things. When Hennessy confronted her and asked her where she was going, she said she had to go, that a friend needed her. He asked her to stay, saying she could have the bed and that he would take the couch. Katie declined and fled, telling a friend she had been raped, and reporting the incident to the sexual assault response coordinator, and then submitting to a sexual assault forensic examination. A cervical swab obtained during the examination matched Hennessy, so probably no safe sex and condom involved. A month later, Hennessy attended a 4th of July party on base. A German national we'll call Ivy was attending the same event with her boyfriend. Hennessy and Ivy had smooched a couple of times before, but Ivy repeatedly refused Hennessy's invitations to come back to his barracks room, and he similarly declined to meet Ivy in public places off base. While they were at the 4th of July gathering, Hennessy told Ivy that he needed to get something from his barracks room and asked her to walk with him. Once they arrived, he invited her in. She again declined and waited outside for him. When he emerged, they went their separate ways. Later in the evening, after everyone had a bit more to drink, Ivy excused herself from the party to use the restroom. The women's restroom. The women's restroom that Hennessy followed her into. Ivy demanded Hennessy leave, and at first he didn't move, but he eventually left when he heard other people coming. Hennessy found Ivy again after the fireworks, and the two chatted for a few minutes. He asked her if she wanted to go somewhere quiet to talk. Very wisely, she wasn't going to Hennessy's room, and they settled on a more publicly accessible theater room inside one of the barracks buildings. While they talked, Hennessy pulled Ivy's face to him 2 or 3 times, while placing his other hand on her butt each time. Ivy turned her head away and pushed him away on each advance. She told him he needed to stop or that she was going to leave, so he said he'd stop. And then he did it again. He escalated things, pulling his own pants down and again grabbing Ivy's butt. Ivy could see that Hennessy was erect, and he attempted to guide her hand to his penis. As Ivy dashed away from him, Hennessy spat that she couldn't just leave him like that. Following conviction for one specification of sexual assault upon Katie, one specification of abusive sexual contact upon Kelly, and one specification of abusive sexual contact upon Ivy at his general court-martial, the military judge sentenced him to confinement for 34 months, reduction from E3 to E1, a reprimand, and a dishonorable discharge. In his first appeal, Hennessy got some relief for excessive post-trial delay, but his conviction was upheld as factually and legally sufficient. He got another bite at the apple following a motion for reconsideration after CAF decided the Mendoza case. Last but not least, I want to talk about Airman First Class Isaac Surjak. We're staying overseas, but shifting to the United Kingdom. We're just really making our allied nations comfortable with this episode, I know. RAF Mildenhall was Surjak's first duty station, and he, like the rest of today's subjects, was single. He arrived during the fall of 2020 and, pursuant to that arrival timeline, quarantined. While quarantined, he saw someone we'll call Hillary walking outside and decided that shouting at a woman from his window was the obvious next move. So he opened his window and shouted to ask if she would get him some food. She agreed to, even though she'd never met him before, and left food outside his door, exchanging contact information with him. Hillary and Surjak were assigned to the same squadron, but they did not work together, and Hillary lived just 2 doors down, close enough that Surjak could even sometimes borrow her Wi-Fi. Hillary said that their relationship was casual at first, but then it got really weird due to Surjak's overt sexual comments. I mean, I think maybe it started as really weird with the window yelling, but we've already established that Hillary was nicer than I am. Hillary was, and presumably still is, a lesbian, but that didn't stop Surjak from trying his best to win her over, sending a photo of himself with the text, quote, "God, the things I would do if you was straight." He'd bring up threesomes and sexual positions with her, knowing she was not attracted to him or other men. Just a few months into knowing one another, Surjak knocked on Hillary's door late in the evening while she was sleeping. Yes, he was drunk. When she answered the door, Surjak pushed his way in and shut the door behind him. With his stinky alcohol breath, he leaned towards Hillary, who put her hands up and over his mouth. He said he was just going in for a hug and put his arms around her waist. Keeping his arms around her, he sat on her bed and confessed that he had feelings for Hillary. She reminded him again that she was not attracted to him, but that did nothing to dissuade him, so he asked if he could spend the night. His own room was like 25 feet away. Hillary said he could not, that she had to get up early, and that prompted Surjak to run his hands up and down her body, grabbing her butt to try and lift her up and towards the bed. Hillary grabbed his hands, planted her feet, and refused to move. Surjak kissed her forehead and eventually left. A month later, Surjak was bored and decided to visit another barracks room without an invitation. This one belonged to another coworker, who we'll call Brittany. Brittany and Hillary were friends, and sometime after 10 p.m., Surjak knocked. I don't have a lot of context for this, but Brittany thought that Surjak was maybe there to help her fix her car or offer to help her fix her car because he'd previously offered to do so. But instead, he pulled up videos of himself sparring with other people at the gym, which for the record is not smooth, 0 stars. Then Surjak picked some form of entertainment, some kind of actual movie to watch. While seated on Brittany's bed, he asked if she'd give him a back massage. She sort of non-committally patted him over his clothes. Then Surjak closed the computer and climbed on top of her while holding one hand to her throat and kissing her neck. Surjak's phone rang, truly saved by the bell. When he climbed off of her to take the call, Brittany got off the bed. But when he completed his phone call, he picked Brittany up and threw her back on the bed, climbing on top of her and restraining her wrists with one of his hands. She escaped only when he decided to flip her on top of him. Serjak left the room at some point after that. The next day, Brittany told Hillary that something weird happened to her the night before. Hillary asked if it had to do with Serjak. When Brittany confirmed it did, Hillary deemed it a pattern and went to her supervisor and then her first sergeant. The senior master sergeant issued Serjak a no-contact order for both women. A few days later, Serjak called that senior master sergeant and said he needed to get out ahead of something. He described himself as the victim of a sexual assault. He said that the night before, he'd been the designated driver for someone we'll call Jane and her friends. I genuinely cannot imagine someone less suited for the job, in part because it appears he actually drank at one of the parties anyway. Serjak said that at the end of the night, after dropping everyone off, he saw Jane walking towards her room crying. So he intercepted her and redirected her to his room in order to offer her Tylenol and water. For the record, taking acetaminophen while pregnant is fine, but taking acetaminophen after drinking alcohol increases the risk of severe liver damage. You should probably avoid mixing any pain medication with alcohol, but if you must take something, ibuprofen is generally considered a safer choice. Terrible offer for liver damage aside, Jane apparently accepted Serjak's offer generally to go to his room and fell asleep in his bed after talking with him. He said that she awoke in the middle of the night, took off all of her clothes, and made unwanted sexual advances that made him really uncomfortable. He said that Jane assaulted him, forcing him to have oral and penetrative sex with her. Act complete. He said Jane showered, she got dressed, and she eventually took off. As he should, the senior master sergeant reported the alleged assault to the Sexual Assault Response Coordinator and the Air Force Office of Special Investigations. Serjak submitted to a forensic exam, during which a nurse documented scratch marks. But Serjak refused to participate in an interview with investigators. But investigators learned who Jane was anyway, through another woman who was in the car while Serjak DD'd. Jane had arrived at the duty station just 2 weeks earlier. She came in for an interview with investigators who began to suspect that maybe Jane was the victim, not the perpetrator. She explained that she had very little memory of what happened on the night in question. She'd had somewhere between 5 and 8 red Solo cups of whiskey cola and didn't know how much alcohol she'd actually consumed. She did not know Serjak and had not met him before that night. He was someone that a friend brought as the DD, and she met him at that party. She recalled Serjak staring at her during the party, but said he didn't make any effort to talk with her, and she certainly hadn't approached him. During that DD ride, Jane planted one on her friend in the backseat while Serjak drove. And when they arrived back at the barracks, Jane remembered walking past Serjak's room on the way to her own, but that he ushered her inside of his. He told Jane that she wasn't the type of person to be kissing her friend in the backseat of his car because he wanted Jane for himself, which offended Jane because he didn't know her at all, and as she later testified, she was not attracted to him. Double the reason to be offended and annoyed. But because she was offended and annoyed, he told her to calm down, lay down, and to just go to sleep. He pushed her onto her side, and she did fall asleep there. She said she later awoke, still on her left side, but with the hood of her sweatshirt pulled up over her hair and tied under her chin. Her hair was soaking wet, and she was otherwise naked. Jane felt around for her phone and used the front camera to check what was happening behind her. She recorded a short video of Serjak lying there before she got up and tried to leave. Serjak grabbed her arm to stop her, but she shook him off by explaining she needed the bathroom. Behind the relative safety of the door, Jane remembered that she was on her period and had a tampon in when she went to the party the night before. She discovered it jammed inside of her. She later testified that she does not have sex while menstruating. When she emerged from the bathroom, she discovered her clothes everywhere, all over the floor among broken pieces of furniture. She put some of the clothes on, grabbed the rest of her things, and left. The government did not pursue charges against Jane, in part because Surjak declined to participate in any investigation into her purported conduct or any resulting court-martial. At his own court-martial, the panel convicted Surjak of one specification of sexual assault upon Jane, one specification of abusive sexual contact upon Hillary, one specification of assault consummated by battery upon Brittany, and one specification of making a false official statement about Jane. For, the report that he made about her assaulting him. The military judge sentenced Surjak to confinement for 54 months and 100 days, forfeiture of all pay and allowances, reduction from E3 to E1, and a dishonorable discharge. On appeal, Surjak alleged he was selectively prosecuted because of his gender, but the meat and potatoes of his appeal, like all of those mentioned in this episode, was the sufficiency of his conviction for sexual assault, both legally and factually. Returning to the top, the AFCCA reversed the court-martial's findings in Moore's case because the government's evidence was that Abby was asleep and therefore not capable of consenting to the assault. This, the AFCCA contended, put them in a bit of a pickle, charging the offense under the factual theory that Abby did not consent but was capable of consenting, a violation of Article 120, subsection B2A. But proving Article 120, subsection B2B, that she was asleep and not capable of consenting. They concluded that this violated a rule that CAF set out in Mendoza, that it was impermissible for the government to charge an offense under one factual theory and then argue a different offense and factual theory at trial. Bang, bang, boom, legally insufficient conviction. The AFCCA similarly reversed the court-martial's findings in Hennessy's case as to Katie's sexual assault. The court wrestled with this question of whether the evidence actually resolved whether Katie was capable of consenting in her drunken and blackout state. They didn't have any evidence in the record as to what happened between the piggyback ride and the sex. They did have an expert that testified for Hennessy that said it was possible that while Katie was blacked out, she'd had too much alcohol to retain memories, but not so much alcohol that it compromised her ability to know and appreciate her surroundings and engage in totally voluntary sexual activity. So for the AFCCA, the evidence didn't show that Katie was capable of consenting and hadn't actually consented. And because the government hadn't charged Hennessy with sexual assault upon a person incapable of consenting, they reversed the conviction for sexual assault and remanded the matter for resentencing. If you are a longtime listener, it should come as no surprise that the government declined to charge too intoxicated to consent, giving precedential history that makes that particular charge kind of useless. Finally, the AFCCA also reversed as to the findings in Surjak's case related to whether he penetrated Jane, pushing her tampon further inside of her without her consent. Much like Hennessy, the AFCCA struggled with Jane's fuzzy memory and the lack of testimony as to whether her drunkenness affected her capacity to consent. Jane didn't remember events between falling asleep drunk in Surjak's room and waking up wet and half naked. The government, again, perhaps justifiably, elected not to charge this as too drunk to consent, but rather as this sex act occurring without her consent. Sort of approaching it under the only yes means yes theory. The AFCCA concluded that there wasn't enough evidence to show that Jane had the capacity to consent and again had not done so. So they remanded the matter for resentencing. In this trio of cases, CAF confronted the AFCCA's application of the law and started by going back to the basics. In order to prove a sexual assault, the government has to prove two elements. First, that the accused committed a sexual act upon another person, and second, that the accused did so without the consent of the other person. Caff tried to clarify that Mendoza stood for the principle that the government cannot prove the absence of consent under Article 120, subsection B2A, by merely establishing that the victim was incapable of consenting at the time of the act. They really emphasized the merely and highlighted that if the government could just prove lack of consent by showing incapacity, it would make these other portions of Article 120 superfluous. Caff accepted this argument that being unable to consent because of intoxication and being unable to consent because of sleep were indistinguishable, which extended Mendoza from cases that involved being too intoxicated to consent to cases involving being too asleep to consent. Caff tried to clarify that if a rational trier of fact could find from the evidence both that a victim did not consent before falling asleep and that the sexual act occurred while the victim was asleep, the evidence is legally sufficient to prove the lack of consent element of Article 120b2a. They also concluded that alternatively, it could be sufficient evidence of lack of consent if the victim was asleep when the sex act began, but woke up before the sex act was complete, and then, while awake, did not consent to the ongoing sex act. They took that third legal principle and said, in Hennessy's case, that the AFCCA hadn't addressed whether Katie's testimony might get the case there under factual sufficiency. As to Surjak's case, Caff thought that perhaps the AFCCA misunderstood the second principle they enumerated in Moore, that finding the victim did not consent before falling asleep and that the sex act occurred while they were asleep is legally sufficient to prove the lack of consent under Article 120b2a. This is a mess. It seems like this string of cases is Caff in damage control mode. Clearly, the AFCCA found it challenging to apply the principles of Mendoza to sexual assault convictions. These cases are all these little refinements to try and clean up the application of the rules set out in Mendoza, but I don't know that we get the sort of predictability we expect from a rule, from a boundary. I haven't dug in to see if other intermediate courts of appeal similarly struggled, and I think there's probably a pretty interesting law review article to be written on the issue of Mendoza and its progeny across the various courts. But frankly, I don't have the bandwidth to commit to that endeavor. Maybe someone at TJAGLIX can take up the mantle. In each of the cases that Caff considered, the court remanded to the AFCCA to conduct a new review of the factual sufficiency of the evidence consistent with the more allegedly refined framework of legal principles. I imagine it will be a bit of time before the AFCCA makes it through all three cases because they each require a slightly different approach. But I will do my best to catch any updates on them and get them posted on the Conduct Unbecoming Instagram. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time so we can weigh together whether using the bathroom anywhere but home is worth it. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense or their new preferred name, the Department of War.